Hello, I'm Andrew Feldstein, the founder of Feldstein Family Law Group and the host of Ask Andrew. Ask Andrew is an internet-based live question and answer show about divorce. I'm in my office at our headquarters in Markham, just north of Toronto. We have other offices to conveniently help our clients in Mississauga, Vaughan, Oakville, and the Bloor West Village neighborhood in Toronto. This show will focus on Ontario divorce law, but most will also apply across Canada with some difference in Quebec. As I speak to you, we are live on the internet on Thursday evening, May the 5th, but you may be watching the show on youtube.com after putting Feldstein Family Law into the search bar. YouTube has all our earlier Ask Andrew shows, plus many video blogs produced by our firm's lawyers explaining many aspects of family law. There are 3 ways to ask a question tonight. Please call us at 1-800-498-3486. One of our staff will answer your call, find out what your question is, and put your call in line to be taken by me. You can send a text. The phone number for sending a text is 416-303-8307. Or you can send an email. My email is andrew@feldsteinfamilylaw.com. Please make sure your question as asked on the show does not identify you. We want to make sure your privacy is protected. Questions stay on the internet for a long time. An hour goes very quickly on Ask Andrew. If we do not get to your question, our 3 websites might have the answer for you. Separation.ca is our main website. It describes how we work with clients, and it has easy to find information on all aspects of divorce and family law. We also have FamilyLawHelp.ca. FamilyLawHelp.ca explains everything you need to know to help you decide what aspects of your family law problem you can work on yourself, and when you really should get help from a lawyer. This concept is called unbundling. Our 3rd site, which is itstimeforjustice.ca. Itstimeforjustice.ca has 2 white papers I've written explaining to Canadians in general and politicians and journalists in particular ways to make the family law justice system operate more quickly and less expensively. And in the next few weeks, we will add a white paper explaining the real-world aspects of self-represented litigators in family law court. That is a legal term for people who go to court without a lawyer. In my mind, that's a serious mistake, but we try to help people who are doing that. We at Feldstein Family Law Group have a free of charge initial consultation if you are looking for a family law lawyer to give you an opinion, well, to provide you with information is the correct term, it's not an opinion, on your situation. Lastly, I really do know what you're going through. I underwent my own divorce and separation. I separated from my former spouse 3 years ago. I understand the emotions and the stress that you're going through. I particularly remember the feeling of uncertainty that a person feels at the time if they're going through their separation. There's a tremendous amount of stress and anxiety, especially for a type A person, and you can imagine I'm a type A person. And what you feel is you're wondering, what is my relationship going to be like with my children? How often am I going to see the children? Am I going to be able to afford a home? How much money am I going to have? What can I do with my kids? All sorts of things racing through your mind. And there's a lot of uncertainty and stress until you get to the place where you actually have a resolution and can understand how to move forward with your life. Now, before we go on the air, we regularly receive texts and emails from people during the week. And when that happens, we have them and we're ready to go. So I'm going to start, and I apologize when I look over at my computer to monitor because that's how I see the questions that are coming in or if people are on the phone. So the first question we received in advance was from Ellen. And Ellen writes, I received an email and a sworn financial statement from my separated husband's lawyer less than 10 days ago and received hard copies yesterday. The separation and assets valuation date is June 30th, 2010. I have told this lawyer that I disagreed with the separation date. My questions are related to assets, equalization, and separation date. My husband threatens to use the 6-year period limitation for equalization if I delay the proceeding. The 6-year limit is June 30th, 2016, which is less than 8 weeks away. What are my options? I want to start by saying there are limitation dates in order for people to divide their properties. This person is right. It is 6 years from the date of separation. It can also be earlier than that if you're divorced. It can be 2 years from the date of divorce or 6 months after somebody dies. Now, what's really critical about this kind of situation is fairly common, and why I say to people you don't always want to wait to what you say is the date of separation, is two people may have a different date of separation. And if two people have a different date of separation, you need to assume, if the limitation period has not passed yet, that they may win on that issue. So you should immediately commence your application, put your date of separation down, but then you know you made it within the limitation period. So for Ellen, you should be hiring a lawyer right away and starting your application, which needs to include a claim for division of net family property. To me, that's the smartest and best option because you won't get in any trouble. 2, over 80% of assets are 2 investment properties which we own jointly and with others, and a few jointly owned foreign bank and investment accounts. He has spent most of the money in these joint accounts on tuition fees for our adult child without my consent. There's no money left in these joint accounts. Do I get 50% of the latest appraised value of the investment properties? Well, there's a few different ideas going on here. When we start with equalization of net family property, we have to deal with it based on a certain specific date and time. If the husband's right that it's June 30th, 2010, then that's the starting point and that's the date we look at. However, Ellen could be right and it could be a later date. Then there's an argument of who owned the assets. If they're jointly held assets, it continues rising over time. So in a situation, if the husband owned the asset, it would just be his. If it's joint, it's both of theirs. When it's joint, you share in the future growth. If it's one person, they're taking the risk post-separation, but that is subject to arguments that somebody has a beneficial interest in that property. Now, if the husband used that money to fund the child's education, well, you have to get into doing all the debits and credits to see, should the husband have been paying child support? Should the husband have been paying spousal support? What are his credits for what he paid for? What should you have contributed to the post-secondary expenses? And what should the child have contributed? So there's a lot of different moving parts with that kind of question. Here's the next one. He has a pension in foreign currency. Can I request my 50% in foreign currency? The exchange rate is not in my favor if I take Canadian dollars converted at the 2010 exchange rate. Well, it's based on what the pension was worth on the date of separation, which means you take the valuation as it was on that day and the exchange rate as it was on that day. And that tells you how much it's worth in Canadian dollars. Now, the interesting aspect of this is if you don't agree with that separation date, it may be a date that's much later. And therefore, you're going to have a fight over what's the correct separation date. Now, Ellen has some more questions for me. My separated husband put me down as a spouse and forged my signature on a mortgage application for an investment property in 2013, and he has power of attorney on my RSP until I removed him in August 15. Will these have an impact on the date of separation? Well, the fact that he forged her application is going to impact the argument on date of separation because now he has a question of credibility. Is he honest? If he forged your signature, it sounds like he's a dishonest man. And if he's a dishonest man about that, why wouldn't he be dishonest about the date of separation? That's my viewpoint on that. Judges can have different viewpoints if that's in court. Her next question is, can I move to direct negotiation by filing sworn statements? All the assets that I own are jointly owned with my separated husband anyways. Well, you still need to do the sworn financial statement. You always need to do it because an agreement could be set aside if you haven't done it. And if you're going to commence the court application for equalization as a result of the limitation period rapidly approaching, then it's clear. You got to do it. So just do it. Ellen asks, can she engage our firm to handle that now and review her separated husbands and financial statements and alimony issues later? How should she proceed? I've said this. We're happy to help you, but you need to do an application right away. You need to get the financial statement done right away. There's certain things you can do to extend the limitation period. such as a toll. It's called a tolling agreement to extend. But the problem is you need him to sign it. It's getting close. It's at the point in time, unless his lawyer agrees in writing to that, you got to go with the application right away. Now, I see a text message just came in. I have been paying my wife's spousal support of $5,000 per month and $7,000 per month in child support. I've been paying since 2012, but I have no separation agreement. How can I claim the spousal support going back to 2012, even though I only signed the separation agreement, sorry, a typo, last month? Well, to begin with, what this person is asking is about spousal support. Spousal support is tax deductible to the payor and tax inclusive to the recipient of spousal support, providing there's a written agreement or a court order. So, assuming this is a written, there was a written agreement, it means spousal support would be tax deductible going forward. This person wants to turn their past payments to be tax deductible as well. Now, this can only be done in a separation agreement and in an agreement, or a court order for that matter, if you go back 1 year in this situation. And it's not one calendar year, it's the year before. So in other words, we're sitting here in 2016. You could go back until January 1, 2015 and make the payments this person made tax deductible to the payor and tax inclusive to the recipient, only if the two sides agree to it. If they don't agree, then you're not going to get that tax deduction. The challenge, of course, is getting the other side to agree with that. Now, that means the years 2014, 13, and 12 are done. You will never be able to deduct them. And if you get to January 1, 2017, then you will not be able to deduct 2015 anymore. That would be a limitation date regarding that issue. So, thank you for that question. It's a common question that people get into, is dealing with their support issues and how to move forward with them and trying to get as much tax deductibility. I'm often asked on that issue that how do people or why does somebody who's a recipient agree to that? Why would they agree to the payor getting the tax deductibility? Well, the only reason they're going to agree is when you're calculating the retroactive payments that were made voluntarily, the payor may turn around and say, if I don't get the tax deduction that I asked for, I actually overpaid you. And if I've overpaid you, I want you to pay some money back. In that scenario, that person may be motivated, especially if they're in a much lower bracket, because they may not pay many taxes on it. In addition, another really interesting point that comes up, and may seem a little unfair, but the recipient of child or spousal support can write off their legal fees associated with getting the support. The payor can't do that to defend, but the recipient can. What does that mean? It means when you're in that negotiation for the retroactive support and the recipient is finding out, as in that past scenario, they may have to take in about $80,000 of spousal support, that they can then offset that additional income with some legal fees that may significantly reduce what their obligations are. Now, here's a text message that we received earlier today. And this person asks, hello, I was reading some case law on your website, Macbeth. It's a 2012 decision. I'm 29 years old and have been a legal crown ward in Ontario since I was 16. I have an ex-therapist who I no longer work with, who has become a mother to me. I would like to be legally adopted by her, especially since I'm battling a chronic illness that could end up killing me any day. It's a sad story. She has 3 biological children. I have 1 son, but I'm not with anyone and have never been married. How can I go about being legally adopted by this woman? Age is 43, and legally, as long as I didn't ask her to change her will, would it make her responsible for me, since I'm an adult? Looking forward to your answers. Thank you. Well, first of all, it's really an important question, distinction that there's an adult, because if this person is truly an independent child, an adult, then by adopting them, you're not creating any financial obligations for yourself towards a child. And believe it or not, adults can be adopted. It can happen. You need to go to court to get that order. I haven't dealt with one of these adult adoptions in a number of years, but the last time when I dealt with one, the key issue was it a real and meaningful reason for that person to be adopted, not some inappropriate reason. And from reading this, I think this person would probably be successful in their claim for an adoption. I'd be surprised if they weren't. It would make a lot of sense to me. It's just a matter of there needs to be some work done and you need to obtain the court order. The next text question that I received earlier today is the following. I went through your website, separation.ca. It's very useful and very informative. I thank you and your team for spending a tremendous amount of time to create videos to educate clients. And I have a few questions for you. I am willing to negotiate, but my spouse is very uncooperative and purposely avoiding all the requests. She failed to respond to the lawyer's letter. The lawyer went on and commenced the court application. The process server made 2 attempts to the matrimonial home, and she was not found. He tried to serve it in the last known address, and the old man there refused to accept the court application. Next step, I believe, is to get an order for substituted service. Once a motion is brought up for substituted service, how long would it take for the judge to grant the order? Is there any way of checking the status of the motion with the court clerks? Well, it sounds to me like this was done as a 14B motion. What does a 14B motion mean? It means that it was done where you simply filed materials over the counter and the lawyer did not go to court. On other occasions, people will do this as a motion and go to court and appear in front of a judge. The difference is, one, you're paying for a lawyer to go to court, you're paying for their attendance and their time waiting and their time preparing to be at court to answer questions of the judge. If you do that, you're going to get your answer right away and probably have your court order signed that day, but you're going to pay more. If you do it by a 14B, because the lawyer isn't attending and the process server is filing the material, it's going to cost a lot less. The challenge with a 14B is sometimes it can take a long time to get back to you. Some courts have a lot more resources than others. So for example, in my experience, Toronto has the most resources. And Toronto, you can usually get your 14Bs back in a couple of weeks. Other courts that don't have the same resources can take months until you get your 14B back. So that will be very frustrating, and I can't even begin to say how long it's going to be because it depends on where this particular case is taking place. The second question this person asks is, I'd like to force the sale of the matrimonial home too. How can we speed up this process? Now that's, I think, a really good question. I've actually had an argument about this with a lot of lawyers because the family law rules says that in every case you need to have a case conference before you're permitted to bring a motion. What is a case conference? A case conference is an opportunity where the parties file briefs about a week before the conference for a judge to read, and they attend before a judge who will typically give them about a half an hour to talk about mainly the process of the case, and if you can work out some resolution, try and work out resolutions as well. And the rules say you got to have that case conference before a motion, but there are some exceptions. And one of those exceptions is a summary judgment motion. And I would argue that a motion for the sale of the matrimonial home is just that. It's a summary judgment motion, an exception to needing a case conference. Therefore, as soon as you've done your application, they've done their answer, and you've done your reply, you should be able to bring your motion for summary judgment to force a sale of the matrimonial home. Somebody may argue that you should have had your case conference, and a judge could be sympathetic to that, but I do believe you meet one of the exceptions, meaning you should go do that right away, especially if you're in a hot real estate market like it is right now. Now, 3, how court would look at this type of uncooperative, high conflict spouse when it comes to divorce, and share your experience and things to consider when divorcing a high conflict personality spouse. That is a real loaded question, because if you're dealing with a high conflict spouse, you're going to have one of 2 choices to make at the end of the day. Number 1, wave the white flag, capitulate, do it as they say. It won't make you happy and it won't work. It will reduce your legal fees. The other option is you're going to have to dig in your heels and you're going to have to fight for every last step, because you will find the high conflict spouse will look to find conflict and try to create conflict with everything to do with your children, and you're going to need every iota of your energy and your passion and your love for your children to make sure that you fight to stay there with them, trying to make sure that your kids have two parents, because a high conflict spouse will frequently try to alienate you from the children's lives, which is one of the worst things anyone could ever even imagine experiencing. Now, I do want to remind everyone that we have all of our contact information here. You can call us at 1-800-498-3486. You can text us at 416-303-8307, or email me, andrew@feldsteinfamilylaw.com. I'm having a distinct feeling that the Raptor game is probably impacting the lead-on of the text questions, and well, I see we have more text, but I think some people may be choosing the Raptor game over my show, as disappointing as that may be. Now here's another text message that just came in. My wife wants me out of the house because she wants a divorce. Do I have to leave the house? Can she force me? Well, no, she can't. If you're married, both of you have an equal right to possession of the matrimonial home. And that means just because she tells you to leave, you don't have to leave. Not at all. There is a small caveat to that, though. If you think that your spouse will falsely report you with an allegation to the police that you've assaulted them or threatened to assault them or threatened to do something to them, the police may come and arrest you. And if you're worried that the police will come and arrest you, then I would suggest that you leave the home but try and negotiate a schedule with the children, because I'd rather the person leave the home voluntarily over the alternative of being arrested by the police and having to deal with criminal charges as well as a family law case. Now another text message just came in, which it seems to me the same text question came in twice. So I'm going to go back to some of the questions we received from people prior to the commencement of the show. And the next one is this. My sister is married to a bully who drinks too much. They're sort of separated, but not really. She wants him to move out, but he says it's his house too and he's not leaving. He sometimes eats meals with my sister and their daughter, and sometimes still sits in the living room watching TV and drinking beer in the evening, but he sleeps in the basement. So far there's no violence, but he's still in the way and still nasty. What can she do to get rid of him? Does she call the police? I don't think he's committed any crimes. Well, if he hasn't committed any crimes, then you don't call the police. That's the answer. You call the police when someone does do something. The question is, what he's doing, is that a crime? Well, he drinks too much, he's not hitting anybody, he's not assaulting anybody, and he's sleeping in the basement. That doesn't sound like it's a crime. I'm not a criminal lawyer, but it doesn't sound like it's a crime. And like I just said to the text message from the other person, that person doesn't have to leave, and this person asking the question, your only real option is to commence a court application and to ask a court for an order for exclusive possession of the matrimonial home. I will tell you that since this question was for somebody's sister, she's not in a good place, because it's very, very hard to get an order for exclusive possession of the matrimonial home. Husband is doing certain things to protect himself. He's moved to the basement. He doesn't sound like he's creating that much conflict. He's eating with the family. He still watches TV with the family, and necessarily why shouldn't he be, unless he's doing something to create a scene or cause problems. The real question is how nasty he is to your sister and what he's saying to your sister, and is he doing it in front of the kids or within earshot of the kids? And that's really an important part, because if he's doing and saying really horrible things about your sister in front of the kids, well, that may impact a judge to say there needs to be an order for exclusive possession because the children are being included in the adult conflict, which they should not be. Should your sister call a lawyer? Absolutely. It's the only way you're going to start moving this matter forward. And the other question is, what would a lawyer cost? And it's unfortunate, because this is one of the questions I wish I could answer. People ask me all the time, Andrew, what is this going to cost? And the problem is I really don't know. A family law case can have negotiations and go on for a couple of years. You can start a court application. You may have a trial, or you may not. In a family case, you have a case conference, you have a settlement conference, you have a trial management conference, you have a trial, you may have motions. How many of those attendances are you going to make? How long are you attending? How litigious is the other lawyer? Two good lawyers hopefully settle the case early on. But if it's not two good lawyers, or even can be very talented lawyers, but they're fighting and there's litigation issues, you can spend a lot of money. And if you're spending a lot of money, you're stuck. You're really stuck in that place, and there's not much that you can do. And when you get stuck in that place, you want to try and move forward. But it's just not always possible. And where does that leave me in answering the question, how much is this going to cost? Some cases will cost a few $1,000s if people are really amicable, and the really awful cases get well into 6 figures. And I'm sure that's not what people want to hear, but that's the reality. And there's your encouragement from a financial perspective to resolve cases. I know one judge, he always says you have a choice to make as you're staring at the abyss of litigation, which is, do you want to pay for your children's university education, or do you want to pay for the lawyer's kids' education at university? I think the answer is rather obvious, but some people, they can't get there. I mean, I always remember I had one case where we're sitting in court, I'm one of the lawyers, another lawyer who was very senior is there, and the other lawyer was raising arguments about the child's dolls and making sure he got the equal number of dolls as the mother did. And the judge simply said, counsel, how much do you think all these dolls cost? And the other lawyer said, oh, Your Honor, they're very expensive, probably $400 to $500 for all of them. And the judge said, and how much is this family spending on the two lawyers being here to argue about it? I'm not dealing with it. And the judge was right. It's just too expensive. Now I see we just received another text message. I have a joint account with my elderly mother. This is really my mother's money and not mine. My lawyer tells me that I have to include it on my statement. I don't agree with my lawyer because it's not my money. I also have joint ownership on my mother's home and I do not live there. Well, the lawyer is 100% right. It should appear on your statement. However, you put it on your statement, and when you put it on your statement, you note that you're just holding it in trust for your parent or your mother, and it's not really your money. That's the critical aspect, because if you put it out there and you say you got it, the other side can't have that aha moment, I caught you in a big fat lie because you didn't put it on your statement. You did, you told them about it, and then you're saying why it doesn't count. There are cases that support the proposition that a parent is going to put money in a joint account or put a house in a joint account with their children because of right of survivorship and not wanting to pay estate taxes. It makes sense. However, you need to be very careful when you do these things, because you're asking for trouble if you put something in a joint account and then the child uses the money for themselves, because that's suggesting it's really the child's money, or the child takes the income from it, or when the child has a house in their name and they go apply for a mortgage on that house and don't disclose that they're holding it in trust for their mother. So in principle, the idea can work, but then it's a question of what do people do with that after the fact that can change the planned characterization. Now, I got a text question following up on an earlier question. The person says this: I am watching your show right now. You answered my question about substituted service, and thank you so much. The motion for substituted service was brought up in Newmarket Courthouse, so how long it normally takes for a judge to grant the order? You need to understand that the Newmarket Courthouse is a very underserviced court region. The Toronto Courthouse has a tremendous amount of resources, and that's why I use that as an example. Newmarket, you might be waiting for a few months until you get it back. You may not, but frequently it can take time. You also want to know what you can do to follow up. Well, you can't go down to the courthouse and ask them. You can hire, your lawyer can hire their process server to go find out the status of it, but it's hit or miss. It could be on a judge's desk. And if it's on a judge's desk, well, how many of those 14 Bs does that particular judge have to work through? That judge may have more than others. That judge may be on a vacation. So there's a whole bunch of possibilities of what will impact the timing of when it's going to come back. So unfortunately, I can't really give you any type of set deadline to say 2 weeks like what I usually see in Toronto. It's just plainly going to be longer. There's way fewer judges in Newmarket. And it's an overtaxed court. The government hasn't given it the resources that it needs in the same way that it has with a court like Toronto. Sorry, but that's life. Now, next question I have that came in before we went on the air is, I'm tired of being married. I know it sounds terrible, but I just want to get my life back and have time to myself and get my hobbies back and have time with my friends. Am I allowed to get divorced just because I want to? It may sound terrible, but yes, you are able to get divorced just because you want to. We live in a country that allows for no-fault divorces. That means everyone who is married is entitled to get divorced without having to determine who was at fault. All you need is to be living separate and apart for a year. So in your situation, if you want to get divorced, you have a discussion with your spouse. You let them know that you now want to separate. Probably a good idea to hire a lawyer. Either have the lawyer send a letter or you send an email confirming it. And now you're separated. You can go do whatever you want with your friends, carry on however you want, and wait the 1 year. After the year is up, then you can apply, well, you can apply for the divorce before the year is up, but you're not eligible to get the divorce until after the year. And after the year is up, go get the divorce. Go take it out and you're free to do it. The next part is, do I need some legally approved reason? Do I need to get a boyfriend and commit adultery? Well, truth of the matter is, in Ontario, just about all divorces are based on the grounds of living separate and apart. There are two other grounds that you're eligible to get a divorce for. One is adultery and the other one is cruelty. However, if you were the one who committed adultery, you can't get a divorce earlier than the 1 year because of your own malfeasance or misconduct. So the person who could ask for the divorce earlier than 1 year under the ground of adultery would be your spouse. I've only seen a divorce granted in my 22 years one time on that issue, because why bother trying to deal with that issue when you can just say we've been living separate and apart for a year? It's very easy. So I think I've already told you what you should do, which is your next question. Now the person says, do I change the locks or do I move out, or do I hire a lawyer? Do I talk to him? But then the cat's out of the bag. So let me go through this. Do I change the locks? I've had this question a few times tonight and it seems like a theme. No, you can't. If it's a matrimonial home, you can't change the locks. Until there's a final agreement in place, you're stuck where you are with your spouse living there. So you got to negotiate with him. Do you hire a lawyer? I think you should. It's the only way you're really going to know your legal rights, providing you can afford it. Do I talk to him? Yes. Be open, honest, and candid. If you talk to him, you may not get the reaction you want, but I tend to believe, I certainly preferred when my former spouse, the fact that at the very least she told me that she wanted a divorce, rather than me getting a lawyer's letter telling me that she wanted a divorce. I think that would be a lot worse to hear it that way. The cat's out of the bag. Well, the cat's going to be out of the bag at some point. If you want a divorce, you got to communicate that. Now, the next question that I got earlier is, she keeps threatening to call the police. My wife gets mad pretty easily, and a reasonable discussion turns into a shouting match far too often. She keeps threatening to call the police to get them to throw me out of the house. I've been following the Jean Ghomeshi assault trial that was going on a little while ago, and I saw the awful things that can happen to a man accused of this kind of crime, even before a judge decides if he's guilty or not. Is there some way I can protect myself from being evicted? Would the police arrest me? What about false accusations? Well, let's start with the fact that if your spouse accuses you of hitting her or threatening her, it is highly probable that you will be arrested, removed from the home, and you will only be allowed back there one more time during the criminal proceeding with the police present in order for you to remove your personal belongings. As we all know, Mr. Ghomeshi was found not guilty of the criminal charges, but it's a pretty awful prospect. What can you do to protect yourself? It's very hard to defend yourself from getting charged. And if your spouse phones the police and says, he said he's going to kill me, well, you could be charged with uttering a threat. And how you deny that at that point is virtually impossible. So what do I say to my clients? If, as I said earlier in the show, if you think this is going to happen to you, it may be smarter for you to leave the home and avoid the problem. It's not really what you want to do, but you may be better off. I saw one of my cases, it was interesting. The husband had a strong feeling the wife was going to accuse him of assault, and he put some form of grease or things on his hands so that if he touched someone, he would leave very clear marks that he actually touched them. And the wife called the police and accused him of hitting her, and he showed the police that if he touched anything, the marks that his hand would make. And in that particular situation, the police didn't lay charges. Would I count on that? No, not so much. As I said, you want to avoid criminal charges? Get out. You're picking the better of two evils when it comes to that. Now, we did receive another text message that just came in. This one is, I signed a separation agreement 2 years ago, but I never included the family cottage that my father gave to me before he died. My ex-wife thinks it's in my mother's name. I never told my lawyer the property's in my name. Can I get in trouble now for what I did? Yes, you can. You swore a financial statement. And when you swear, whether it's a financial statement or an affidavit, it's a statement under oath, the same as a sworn statement that you would give at a trial. That means you have committed a crime called perjury. It means that your former spouse may try to open up and argue the case again, because there's certain rules with respect to inheritances. So let's talk about what those rules are and how this may impact the case. We start with, if you got this inheritance during the marriage and it's the family cottage that you and your family ordinarily occupied at the time of separation, that could be a matrimonial home. What am I saying? I'm saying people can have two matrimonial homes. You can have the home you live in the city, and if you have a cottage in Muskoka and you go there as a family most weekends in the summer and maybe take a vacation there in the summer, irrespective of when you separate during the year, that may also be a matrimonial home. And why that's so significant is because if you receive an inheritance that goes into a matrimonial home or is a matrimonial home, you can't exclude it. In the simplest terms, it means you get no credit for it being inherited and you got to share it. And if that cottage had some significant value, your former spouse is going to come after you for that. And even though she signed a separation agreement, she did it by relying on your false statement. And if she finds out, she will go back to court and a judge will set aside the agreement. And she will get what she should have gotten. And if the cottage has gone up in value, she may even successfully argue she should get it based on, well, it would be based on the date of separation value, but post-judgment interest would be running. And if you have any other issues that you may have to litigate with your former spouse, such as your income, every time a judge will see you, if she's saying you make this and you say you make this, you now have the litigation reputation of being a liar. And that's going to have consequences that the court's going to believe her over you when it's relevant to your income. So that's going to create a big problem. I want to remind people again, our phone number, if you want to call, is 1-800-498-3486. Texting, which seems to be vastly more popular tonight, is 416-303-8307. And email, andrew@feldsteinfamilylaw.com. And please keep in mind, it's all posted right there. Now, the next question that I received is the following. My in-laws think they're back in the old country. My husband moved to Canada with his family when he was 10 from a country where religion influences every aspect of life. He's very Canadian in the sense of believing in equality and fairness and the need to obey Canadian laws. He's 35 now, and we have a boy who is 9 and a girl who is 8. My problem is his parents who still think they're back home. They're driving us apart to the extent I'm thinking of getting divorced. They only pay attention to my husband and our son, ignoring me and our daughter. Do his parents have influence in a divorce trial? This is a sad story that I see all too often, where some people are really in the throes of a divorce that's created by their parents. And before you even get into the family law issues, I would have a couple of suggestions for this particular person. Number one, talk to your husband about what the problem is in the marriage. Maybe go for marriage counseling. Try and deal with the issue, because I'm not sensing that there's anger or dislike to your spouse. It's just you're having a problem with his parents. And I get that he may want to have a lot of respect and give deference to his parents, but try and see if there's a way for the two of you to work this out before you go down the divorce route and impact your children and the rest of your life the way it's going to be impacted. Now, to answer your questions, You're worried about how the parents are going to influence in a divorce trial. They're going to be a big influence. In most cases, they are. If they're the ones who have more money than your spouse, they may fund the litigation. They may put pressure on him with respect to litigation. They may want to be the surrogate caregiver to the children. They may offer daycare services to your children, or before school and after school daycare, I should say, instead of you if you're the one doing it. There's many cases I've seen where I've been involved or against people whose parents show up at every court appearance, and the child knows the parent is paying the legal fees, meaning the child knows that the parent is going to have a significant impact on any decision to resolve the case. So legally, the parents don't have much say, but practically, they may be an extremely important decision maker in this particular case. So be cognizant of that. And they almost certainly will end up involved in the case. I would be very surprised if they didn't. Now, we have some more questions that we received before the show, and the next one is, when I looked on the internet, I couldn't find anything about using a paralegal to help me in my divorce. And I'm going to start with, paralegals are not permitted to practice family law. And I, quite frankly, think it's a good thing. Some people may say, well, of course, you're a lawyer. Why would you think paralegals are a good thing that they're not practicing? Because family law is a lot more complex than most people appreciate. I believe that we deal with about 35 statutes. I may be a little off in the numbers. And there's all sorts of very technical nuances. And there's times I've seen when people come in or been on the other side and they said a paralegal will help them with their case. What they have done is turned their case into a monstrosity of problems. I actually saw one case where a paralegal advised the client how to hide several $100,000 of money. And how he suggested that it be hidden was by paying it to the paralegal. Paying the money to the paralegal, who I found out was subsequently jailed because he didn't return the money. It's shocking. That's one paralegal. I can't say all paralegals are going to be like that. I'd be shocked if they were, quite frankly. I'm sure there's many, many paralegals who are honest and have integrity. But the point is, there's a lot of things. Paralegals have not spent the years of education honing their skills to become family law lawyers and training in the same fashion. And I don't think it's a good idea for the public. I think the practical reality is, if our government is looking for alternatives, they need to look at themselves and look at ways to make the court system more efficient. I mean, I'll tell you one of my I have two really big pet peeves about the court system. And I'm going to explain them to you, why fees are so high. When I have to go to court, sometimes I will wait 3-4 hours to see a judge because there's a number of cases on the judge's list. And I can't understand why in 2016 I can't make that appearance by Skype or by conference call, so that my client does not have to pay what they're going to pay for me to drive to court, sit there and wait, and drive back. That's the kind of waste that's going on. Or I'm going to tell you what it's like to try and book a court date for a conference at the first time. If I want a case conference date, I have to write to the other lawyer and say, what are your available dates? Try and make sure we're both going to be available at the same time. That sounds easy enough. I write them, I ask for their dates, they give me 2 or 3 dates. Then I write the trial coordinator, and I say to the trial coordinator, do any of these dates work for you? And the trial coordinator can say, sure, here's a date. Or the trial coordinator can say, no, here's not, those dates don't work, go get more dates. And then we go right to the other side, get the response, write the trial coordinator, and do this dance over and over again. Once we settle on a date, we then have to do up something called the case conference notice, give it to our process server. The process server then goes to the courthouse, puts a stamp on the document to get it issued and put in the court record. Then they bring it back to our office. We have to take that case conference notice. Then we serve it on the other side that's already agreed to that court date. After we served it on the other side, we have to do a proof of service, which is an affidavit of service, and file that with the court just to secure a court date. When I go to international family law conferences, I speak to other lawyers. They can do it all electronically. Boggles the mind, 2016. This is dealing with cases in a court system in the same way as we did in 1994. But yet our provincial government has kept us stuck in doing things the same way because they haven't wanted to invest in the proper infrastructure of the court system because they're not capable of doing it. It's just not right. So when you're asking, why does the court system cost so much money? That's a big part of the problem because they haven't automated it. Why in 2016, every time I have a court document and I want to file it, I have to send a process server down to file it instead of being able to do it electronically? I find it mind-boggling. Just mind-boggling. But that's where we're at, and that's the system we're stuck with. Now here's another text message that just came in. My wife works for my company as an employee. I would like to initiate a divorce. She has been working for me for 10 years as my controller. I'm worried she can sue me for wrongful dismissal. Is this a possibility? If she does sue me, can I include the debt on my net family property statement? This sounds like a very intelligent, sophisticated client because he's right. Theoretically, there's a few things at play here. If she has a wrongful dismissal suit against you, then that's going to reduce the value of your business because your business has a potential liability. The other piece that happens is if you had to pay a significant wrongful dismissal payment and damages, it's reduced your business value. And then there's a question of, is it an asset on her side as well? And if it is, that increases her net family property and it's going to net out to zero. You may also, if she sues you post-separation, say, well, if I'm paying you the termination pay, do you really need spousal support from me anymore? So there's lots of different things in play. In my experience, there's only been very few cases where people have initiated the termination pay against the former spouse because they're going to get their share of equalization in that family property, and if they're entitled to child and spouse support, they're going to get that. So typically, that hasn't happened. I'm not an employment law lawyer, so I'm not going to talk about the merits of that particular issue, but that's how that particular one would generally work. Here's the next question I have. The alternatives to real divorce, oh sorry, I'm going back to the question before, they had another one. This person also wanted to know about collaborative law. This is the one who asked about paralegals. Collaborative law is a really good alternative dispute resolution process in order to work out and help people get to a deal. I'm going to explain a little bit about collaborative family law. The idea is people are supposed to work towards solutions in a holistic way, trying to take into account each other's needs and trying to get to the deal. And part of that is trading off certain things with one another. However, it's not supposed to be something where somebody waves a white flag and capitulates. And in my experience, collaborative law has some good cases to be involved in and some bad cases. When there's a power imbalance between the two parties, I don't believe it's a great case, and I'll tell you why. The biggest nuance of collaborative law, besides the style of negotiation, which is different, is that the lawyers themselves, if the case goes to litigation, have to withdraw from the case. They can't take the case to court. The client is forced to start over with another lawyer and go through the costs of starting with another lawyer, and that's supposed to be an impediment to leaving the process. And what I've seen happen in a number of collaborative cases when I've been I do collaborative, but when I've taken over cases from a collaborative file so people hire me to go to court for them, is, and the weaker party, being the one who doesn't own a business, is asked for all sorts of documentary disclosure. The other side doesn't give it. They give what they please to give. And in addition to that, the other side strings them along that they're close to a deal, close to a deal, close to a deal. And the client comes in and says, I spent $20,000 on this and I've got nowhere and I'm so close to a deal. And I'm thinking, of course, the other side is intentionally stringing you along so that you have very little money and you roll over and capitulate and sign the deal because they don't think you're going to go to court because you got them that close and that vested in that really bad deal. And there's many occasions I've seen people actually sign that deal and then come to me even 2 or 3 years later saying, I want to set aside the agreement. So what I say is collaborative cases can be very good to do collaborative law, but if you're going to do it, make sure it's the right case where people are going to behave properly to one another and that the power imbalance should not exist. If there's a strong power imbalance, I don't necessarily suggest resolving a case in collaborative form. You could say you're going to negotiate with the collaborative style, but not sign a collaborative agreement that requires your lawyers to bow out. So that way, if you're being strung along like that, your lawyer can just convert it into litigation. Next question from the same person was, and when I visited your website, separation.ca, I saw reference to arbitrators and mediators. Are they real lawyers or does it matter? Well, mediation is a way to try and work out a difference. And there's different styles of mediators. Some mediators, and this is the more common theme, view their role as being someone who has to help facilitate the parties resolve a case. Other people view it as, you're coming to me because you want an opinion to try and help you get to a decision based on what people think will happen in court, and that's an evaluative mediation. It depends where you are in the case of which is better. Do you need a lawyer? Well, I tend to believe on the financial issues, yeah, you should have a lawyer. People who aren't lawyers do not understand the financial issues of family law as well as lawyers. However, if the issues in dispute are just about the children, then you shouldn't hire a lawyer. Lawyers aren't the right people because we're not trained for that. If that's the situation, then what you should be doing is hiring a social worker or a mental health professional, because they have far more experience at trying to help you navigate through the emotional issues that lead to a schedule that's in the best interest of your children. Now, arbitration is something different than mediation. Arbitration is where you hire a lawyer who is essentially your judge, and that lawyer will hear your case like a trial typically and make a decision, which would be a written decision, which would be subject to an appeal, much like a judge would do. When you sign an arbitration agreement, it what empowers the arbitrator to do that, and the arbitration agreement will determine what the issues are that are being arbitrated. You can change the style of an arbitration. It can be dealt with in lots of different ways if you want. It doesn't have to look like a traditional trial, but that's typically the starting point. Some people also do something called mediation arbitration. Mediation arbitration is where they go to the lawyer, hire them to be the mediator, help work out a deal, and if the deal doesn't get worked out, then that lawyer will forget everything that's said at mediation and become an arbitrator and help, and then not help, but then will hear the case and make a ruling, which would be called reasons. Here at Feldstein Family Law Group, I'm the only one that is a mediator. I'm also an arbitrator, so I do mediations. I do arbitrations, and I do mediation arbitration. The next question from this person is, can you explain who's who, how I decide to ask for help in my divorce? Well, you should start with by calling a family law lawyer. I obviously think the lawyers here at Feldstein Family Law Group are the lawyers you should call, but get a lawyer. That's the place to start to find out where you need to know where to go and what to do next. I see that another text message just came in. An old girlfriend wants to move in my house and pay me rent. We are both single and not living in a conjugal relationship. Is there anything I should do to protect myself in case in the future she comes after me for spousal support? We are not a couple, but we used to be years ago. Should I get a lawyer to prepare an agreement? I'm going to start by saying not a smart idea, not a good idea. I'm going to tell you this as a lawyer. It's not a good idea, but also just think about the trouble you're creating for yourself. I remember when I was divorced and started dating. Can you picture if you start dating someone and you say you live with your ex-girlfriend, how well that's going to go over? It's not. It's going to be a significant impediment to you getting into any new relationships. But let's say you decide you're going to go get an agreement drafted by a lawyer that says the two of you are residing in this house, she's paying rent, and this is not a relationship that resembles marriage and you're just friends. Okay, so that's your intention today on May 5th, 2016. But in February 2017, she could say, it changed. Yeah, I still paid rent because that was my contribution to live here, but the relationship changed and I moved into the master bedroom. And she goes in with a camera and takes a bunch of pictures of her stuff in the master bedroom with yours. And then she comes to you and says, you know, I'm really struggling. I need certain medication and my benefit, and I don't have any benefits for my work. You don't have anybody on your benefits. Can you do me a favor and put me on your benefits? And you'll feel bad because she's a friend and she has the same address, and you'll say, okay, I'll put you on the benefits. And this goes on for a few years, and now you decide you want to have a relationship with somebody else, and you ask her to leave the house. And she says, how dare you ask me to leave the house? And the next thing you know, she says, and guess what? I need spousal support now, and I want to stay on the benefits because this is a relationship that resembled marriage. And you're going to say, but we didn't even share a room together. And she's going to say, but here's the pictures of us doing all these things together, because she was smart enough to take her phone and snap pictures all the time. She's going to say, I was on your benefit plan. Look at all the claims you put through for me. You wouldn't have lied to an insurance company and commit insurance fraud, would you? That's the kind of thing you're going to be facing. So from a legal perspective, don't do it. Not worth the rent. From a practical perspective, if you want to date other women, don't do it. You're asking for trouble. I think there's probably time maybe for one more question, because I know we're getting close to wrapping up now. How much money does a divorce cost? It's funny how you get the same questions, and this person wants to know before they call a lawyer and start the process, and the real answer is there isn't an amount. It depends on how long it takes. Some cases will settle at a few $1,000s because people are really motivated to settle and they get it done, and they get it done inexpensively. And other people have a lot to fight about, and if you have a lot to fight about, whether it's money or your kids, you can easily blow your brains out and get to 6 figures and spend years doing it. There isn't a set answer for all the reasons I've seen earlier in the show. The last piece of this question I'm going to answer is the person says, I'm in Toronto. We have 2 kids, 9 and 12. One of those lives in a house. I apologize, I don't totally understand the question as I'm reading it. Is they have 2 kids, they're living in a house worth $1 million with a $300,000 mortgage. They have some savings and investments of about $300,000. They both want to split up. Is there some sort of spreadsheet I can fill out? Well, under the family law rules, there's something called a net family property statement, and that's the form you should use to put the spreadsheet together. But putting the numbers in is the easier part to do. There are always little nuances about taxes and disposition costs that can lead to where there are challenges. And in this case, what's the house really worth? This person seems to be concerned about lawyers' costs with good reason. How much they cost, I said before, they're expensive. And they've asked, can they share a lawyer? Some lawyers will say, okay. I tend to believe if you're going to act for both parties, you might as well send in your deductible to your insurance company for negligence, because you're making a very foolish mistake, because if someone is unhappy with the deal, they're going to ultimately blame you for it, and they may end up suing the lawyer. So most lawyers shouldn't do it. I know here at Feldstein Family Law Group, none of us do it, and I wouldn't allow anybody to do it. I hope you all found that a helpful show. When we started tonight, I said an hour goes quickly. I think we've proven that true tonight. As we approach the end of tonight's show, I want to thank everyone for their questions, and thanks go to all the good people who watched us, either live tonight or on our website on YouTube. Probably more on YouTube tonight, considering it's Game 2 of Raptors and Heat series. In the Feldstein Family Law area, watch us on the YouTube in the Feldstein Family Law area in the future. We'll be back next time on Thursday, June 16th. In the meantime, I remind everyone, there's family law information, which is easy to understand language on separation.ca, on familylawhelp.ca. Thanks for watching. I'm hoping that many of you and more will be back on June 16th to watch us next month. Have a great night, and let's hope the Raptors beat the Heat and go to Miami even at 1-1.